Blake Lively has now filed a motion to dismiss Justin Baldoni's $400 million lawsuit against her. She wants his defamation lawsuit dropped because she said it's just his way of getting back at her for legally accusing him of sexual harassment. Blake's legal team said in the motion today that the Wayfair party's vengeful and rambling lawsuit against Blake Lively is a profound abuse of the legal process that has no place in federal court. The law prohibits weaponizing defamation lawsuits like this one to retaliate against individuals who have filed legal claims or have publicly spoken out about sexual harassment and retaliation. The Wayfair parties have just created more liability for themselves by their malicious efforts to sue Miss Lively into oblivion. And then they ended the memorandum by saying the court should dismiss all claims against Miss Lively with prejudice, deny leave to amend, and award Miss Lively all relief sought. Her lawyers also provided a statement today explaining this, saying this lawsuit is a profound abuse of the legal process that has no place in federal court. California law now expressly prohibits suing victims who make the decision to speak out against sexual harassment or retaliation, whether in a lawsuit or even in the press. This meritless and retaliatory lawsuit runs headfirst into three legal obstacles, including the litigation, fair report, and sexual harassment privileges, the latter of which contains a mandatory fee-shifting provision that will require the likes of billionaire Steve Sarowitz, Wayfair Studios, and others that brought frivolous defamation claims against Miss Lively to pay damages. This means that the other side, Justin Baldoni's team, is going to have to pay for all her legal fees that this has incurred if they throw this out. In other words, in an epic cell phone, the Wayfair party's attempt to sue Miss Lively into oblivion has only created more liability for them, and deservedly so, given what they've now done. The painful reality is that Miss Lively is not alone in being sued for defamation after speaking up about being sexually harassed at work. This is entirely why California recently enacted AB 933, the Privileged Communications Incident of Sexual Assault, Harassment, or Discrimination Act, which codified California Civil Code Section 47.1. While Miss Lively has suffered greatly by speaking up and pursuing legal claims, it is important for other people to know that they have protections and that there is a specific law that expressly protects them from being silenced or financially ruined by a defamation lawsuit because they had the courage to speak up. This motion comes just one day after Ryan Reynolds filed to have Justin's lawsuit against him dropped. So Justin has accused Ryan Reynolds of creating the character Nicepool in Deadpool and Wolverine to make fun of him in a deliberate attempt to mock, harass, ridicule, intimidate, or bully Justin Baldoni. Reynolds didn't deny this accusation in his letter to dismiss, but he did note that the filmmaker cannot sue him over hurt feelings, saying it falls into the First Amendment complaint's general allegation of hurt feelings, which in reality is nothing more than a desperate effort to advance the same curated bully image that the Wayfair parties created and disseminated in the retaliation campaign they launched against Lively in August of 2024. So if a judge does decide to drop Justin Baldoni's lawsuit against Ryan and Blake, then Justin's team is going to have to foot the bill for all the legal expenses that Ryan and Blake have had to do so far because of his lawsuit. If the judge does not throw out Justin Baldoni's claims, then things will continue to move forward like they are, and Blake Lively will have to go through deposition. Now, both teams have said it's too early to offer mediation. Neither of them are looking for that at all, and they both claim they want their day in court, which is not going to be until next year in 2026.